Today, we are looking at a fresh Supreme Court decision, a very interesting decision. Assistant General Manager, State Bank of India versus Tanya Energy Enterprise, decided on 15 September 2025. A very interesting judgment. Now here, Tanya Energy had taken a loan from State Bank of India by mortgaging 7 properties. Over time, the company defaulted and its account turned into a non-performing asset, which we called NPA. SBI began recovery proceedings and even offered a compromise settlement back in 2018. But Tanya Energy failed to honor the terms. In 2020, SBI launched a one-time settlement scheme popularly called OTS 2020 to help the borrower to clear their outstanding dues. Tanya Energy applied under this scheme, but here is the twist. It did not deposit the mandatory upfront 5% of the settlement amount. Despite this, the High Court in Andhra Pradesh directed SBI to reconsider the application, saying the scheme was non-discretionary and should apply. SBI challenged this in the Supreme Court. The arguments were intense. SBI said that the borrower has repeatedly defaulted, ignored the tribunal orders, and has not even made the upfront payment required under the scheme. There is no public duty forcing us to grant OTS, that is one time settlement scheme. On the other hand, Tanya Energy argued that they have already paid significant amounts. The rejection was arbitrary and without fair hearing. The courts only asked SBI to consider our case and not to grant the OTS outright. Now question is, what did the Supreme Court say? The bench held by Justice Dipankar Datta ruled that OTS scheme help banks recover dues. Eligibility condition must be strictly followed. Since Tanya Energy failed to deposit the upfront 5% payments, its application was incomplete and had no right to be processed. The court set aside the High Court orders allowing SBI to proceed with recovery. However, it left a small window open. Tanya Energy can still submit a fresh settlement proposal outside the OTS 2020 scheme, and if the bank finds it workable, it may accept. Conclusion is, courts cannot force the bank to grant one-time settlements. Borrower must strictly meet the scheme's eligibility rules. There is no shortcuts. That's all for today's episode of Tax Decoder. Stay tuned for more insights and how the law shapes our financial and business world.